Former President Jacob Zuma is not eligible to stand for election to the National Assembly because of a prior criminal conviction. This after the Constitutional Court overturned the order of the Electoral Court that found Zuma's sentence and conviction was not a sentence and a conviction as envisaged in a section of the Constitution. Now, the IEC brought the case before the ConCourt on appeal from the Electoral Court, and the main case relates to whether Zuma is eligible to appear as a National Assembly candidate for the party after the IEC initially ruled that he was barred from doing so due to an 18-month conviction for contempt of court. Justice Leona Theron proclaimed that Zuma's disqualification was also because 5 years had not lapsed since the conviction was handed down. For an in-depth analysis of the judgment and its implications, we're now joined by legal expert from Zikalala attorneys, Mpumelelo Zikalala, and we'll try and figure out how things are going there. It's nice to have you. Thank you very, very much for joining us.
Good morning to you, and good morning to your viewers.
So yesterday, Apex Court dismissing the Electoral Court's earlier decision clearing the former president's candidacy for the upcoming national elections. The Electoral Court had always felt that that one needed to be questioned, that judgment. Well, the Constitutional Court did exactly that. So perhaps you want to talk to us between the rationale between those two courts.
Yeah, I think let's start with the Electoral Court, which was looking at the literal interpretation of what Section 47 is actually stating. And even went further and then say, let's look at whether this particular sentence was appealable, what's the effect of that. In fact, we had one court that had three judgments that were speaking about the same thing, but the reasoning was very different. So it was about time that it was going to go to the Constitutional Court so that the matter is done and dusted. However, the ConCourt went a step further and then said, let us look at how this particular text has been written. Let's look at the intention of the section, why it was intended. And it even went further to look at the first interim constitution to say, what was this clause written like? What is the difference between then and now? We want to check and check what is the intention of the legislators or the drafters of this section. It was clear from the conclusion that came yesterday that they wanted to make sure that a person who is going to make it to the list of the National Assembly is someone that has displayed that they observe and obey the law as it stands. So it mustn't be someone that has been convicted for a certain amount of time, and that is after serving that amount of time, they have a cooling off period, let's call it that, of plus minus 5 years, before they're eligible to be part and parcel of the National Assembly. So on that basis, then the court made the distinction of saying, let's make a distinction between the imposing of a sentence and the serving of the sentence. This particular case deals with the imposed sentence only, and regardless of how the serving of the sentence is regulated, it does not change the fact that you are disqualified purely because the sentence has been imposed on you.
Yeah. All right. So, I mean, as you mentioned, at the center of all of this is the interpretation of Section 47(1)(e) of the Constitution, disqualifying anybody that's sentenced to 12 months in prison without the option of paying a fine from being a member of the National Assembly. I mean, it seems quite clear that ruling, and until a 5-year period has lapsed, it seems very clear. Where was the grey area? Where did the confusion come in?
The confusion then comes in when the president issues a remission that says we are going to reduce by 24 months all the sentences of individuals that are serving, I think, sentences which are lesser than 24 months. Then the question is, wait a minute. Then if you are going to do that, then what happens to the initially imposed? If you look at the section qualifying it and giving to specific months, that is Section 47, by the way, what is the effect of the remission on that and the powers that are then imposed? I think another question that came up within the Electoral Act, with the Electoral Court judgment, was the difference between the two powers. Who has more power between the president and using his powers as per the Constitution and the judiciary in terms of being the sole custodians of people that are going to issue out these orders. And the Constitutional Court came back and said, let's settle this dispute once and for all. The court is always going to be the one who's going to issue out orders. The president may have those powers, but those powers do not supersede what the court has done. So in this instance, once the court has decided that is what you have to deal with, the president can only deal with the manner of serving the sentence and not the sentence that was initially imposed.
The court obviously overturning a much criticised ruling by the Electoral Court. My question to you is, what does it actually mean now? What does this development mean for the Electoral Court, its integrity, and does it hint at Electoral Court weaknesses?
I wouldn't say weaknesses per se, but it may be that they got it wrong this time. But I think the beauty of our legal system is that even if you get it wrong, you do have a chance, or there's another court that is higher than you, which will be able to rectify whatever is there. The most important thing that must be looked at is the reasoning that has been stated in those sections and checked. Are they so apart to such an extent that any reasonable individual legal practitioner cannot comprehend how they arrived at that decision? I think the reasons which are stated by the Electoral Court may have been sound to a certain extent. However, the manner of approach in dissecting and trying to adjudicate the matter and the manner in which the Constitutional Court has done so is way different from what the ConCourt was doing. And that does not mean that you must cast aspersions on any of the judges of the Electoral Court. It simply means that they got it wrong. Every single process or every single judge would get it wrong at some point in their time, which is why, by the way, we have this hierarchical system of going from a provincial division to a Supreme Court of Appeals to the Constitutional Court to allow that level of sifting and checking what is correct and what is not correct. Most importantly, though, we then say, after the ConCourt has made that decision, what is it that the ConCourt looked at? Is it something that going forward is going to be practical? Is it something going forward that is going to be able to assist us? I fully agree and now understood much better what the reasoning or the reasoning of the Constitutional Court is, but I do have a few reservations. One, dealing with procedural fairness in a certain instance, in terms of saying, once an objection has been filed against the name of the former president, then I think what the Commission ought to have done was to go back to the former president procedurally and say, here's a complaint against you, tell us what is it that you have to say, and give us reasons so that when we make our decision, we do so after having considered all the submissions of the individuals that were there. I did not see the court in that particular procedural flaw that might have taken place. And then another one, in which, even though I do understand where they are going with the recusal application that they've now extended, but at the end of the day, you cannot take away the fact that these facts are more or less similar. These facts are dealing with the same individual. And the proper thing to do would be to say, if I've taken a decision on the matter and I'm being asked again in a now formal and proper manner to take a decision again, I should recuse myself because I've already placed it on record as to what is my thinking pertaining to that, regardless of whatever that has been submitted to me.
Just a quick one as we run out of time here, and I need to squeeze this in because it's what a lot of people are talking about. They're talking to the fact that either way, former President Jacob Zuma has won. His photo is still on the ballot. He is a key attraction for any MKP voter. They see his face. The party are very happy that it's there. The fact that the president, if he did go into the National Assembly as a MP, would have lost all the perks of being a former president, and those perks. A security personnel that is massive. I'm reading here in the paper, I'm not sure if this is true or not, his salary alone is more than 20 million rand a year with this elaborate security detail and many other things that come with being a past president that is a lifetime benefit. The threat of him losing that versus just becoming an MP, who is the real winner here?
I think the real winner is the former president. He's a politician at the end of the day. And the only thing that he's going to be interested in is within the game of politics, how is it that he's going to remain relevant? Now, if you look at the past 3 to 4 weeks, the name of the MKM party has been in the news, I think, in many times. And I think if they wanted to make sure that the brand is still known by out individuals, they've done so. If they wanted to make sure that the brand is being defended or being perceived as if there's someone who's prosecuting them, stopping them from going to parliament to ulterior reasons, I think the statements that were stated by the party yesterday are a clear indication of that. But there is a grey area when it comes to the perks and the benefits which then apply to the president. I think the drafters of the applicable legislation did not envision that you will find a president which will say, after I have served, I want to go back to the National Assembly and serve again. Firstly, the Constitution does not allow him to do that. It's only the National Assembly in which he can serve comfortably in. And even if he does so, there's a very grey area as to whether the perks will continue with that, because they solely rest within the National Assembly and the internal rules that they regulate and draft on a regular basis, on an annual basis, to say, are you going to keep your benefits as it stands? Currently, there's no provision that would have stated that those benefits would have gone. Once you've received them, they are there up until the National Assembly decides that they must be removed. And I think the manner in which he's been litigating, he would have fought that through to the nail.
Okay, thank you. That's Mpumelelo Zikalala, legal expert from Zikalala Attorneys, unpacking the Constitutional Court judgment and its implications.